Good morning class, our topic is Mabo and sovereignty. We will now present a short video outlining the legal and historical background leading up to Mabo versus Queensland No. 2. Please enjoy the video.
In 1770, James Cook landed in Botany Bay and proclaimed sovereignty and dominion over the east coast of the by then unknown continent now known as Australia on behalf of the British Crown, and claimed possession of that land under the principle of Terra Nullis, or nobody's land. This incursion of Captain Cook would be followed by the arrival in 1788 of Captain Arthur Phillip, who would claim possession and occupation of the land under the same doctrine and for the same king. This despite of the fact that the territory was fully inhabited by aboriginal people who occupy vast tracts of land.
What are they waiting for? This is no longer your world. It's nothing personal. It's just good business.
The legal doctrine of Terra Nullis would be then a ghost that would haunt Australian history until the landmark decision of Mabo and Queensland No. 2, decided on the 3rd of June of 1992. However, the road leading to the Mabo decision would be an uncomfortable one. Decisions such as Attorney General and Brown would go to reaffirm the doctrine of Terra Nullis by reaffirming that land could only be granted to a subject by the discretion of the Crown as a universal occupant. Similarly, Millerpool and Navalco would lead to the dismissal of the Young Goose people's claim for a native title in a decision favorable to the mining industry.
But it was the Racial Discrimination Act 1975 that paved the way for the first common law hearing of native title in Australian property law.
In 1982, a group of Torres Strait Islanders, including 80 Koiki Mabo, would start legal proceedings against the state of Queensland as a reaction to the potential effects of the Queensland Coast Declaratory Act of 1985 to declare retroactively that it was the Queensland legislature's intention in 1879 to acquire sovereignty over the islands, but also to extinguish the land rights of those who by annexation became British subjects. Thankfully, but for the inconsistency that it would cause with Section 10, Part 1 of the Racial Discrimination Act, the state of Queensland would have been successful.
This land came to me through my grandmother and her father.
The question and clarification brought by Mabo and Queensland No. 1 of whether the Queensland Coast Island Declaration Act was valid due to its inconsistencies with the Racial Discrimination Act would clear the way for the claimants to make a successful claim for native title in the High Court in Mabo and Queensland No. 2.
Mabo to me is ultimately as bad as I see it to be because of its potential to destroy our society.
Aboriginal Australians were dispossessed of the land, and what this decision says, it's fairly simple really, it says that where continuing association with the land can be established, a native title
may
exist.
Yep.